Just,
Oh, go ahead. I'm listening.
you got to be honest and upfront with you. Your Honor. Marijuana traces might appear.
He got out of jail. He's not supposed to be using any drugs. Does he have a medical marijuana card?
I have faith.
Your Honor, ready to cook for the people?
Got ready, Your Honor. Good morning to you. Good to see you, Matthew Mansour, on behalf of Mr. Cadell, who's approaching. To my right, Mr. Cadell, could you please state your name for judge since Sheriff Cadell? Your Honor, I have two things for you. I have a green sheet and a bond violation.
Yeah. You can get that up to me at some point.
Okay, thank you.
Thank you. You're asking for an adjournment?
Yes, please, Your Honor. I'm going to start the negotiation process. I just got the discovery, the media discovery yesterday, so it's about done.
Why hasn't he gone over to community correction?
Your Honor, I've talked to him about that. Him and his mother, he's had transportation issues. That is not going to happen anymore. He understands.
I know that.
Because I let him know how serious these matters are, that this court is not one to play around with. And he knows that he could potentially be incarcerated for not drug and alcohol testing. Something like this, it can be fixed and it will be fixed. If you just allow, he will test today, Your Honor.
And a test clean
Sure.
for everything?
Yeah, yes, sir. Even marijuana? Your Honor, 1 second, Your Honor, please.
Okay. Well, May 12th, the last year meeting was Washington.
Last time I did it was Washington Saturday. Your Honor, to be candid with you, to be
Really?
honest with you, of course.
So what changed that?
Just,
Oh, go ahead. I'm listening.
you got to be honest and upfront with you, Your Honor.
Really?
I know how it is. Yes, yeah.
Oh, that's a problem.
Marijuana traces might appear, but he knows.
Marijuana traces might appear. What's that mean?
He used marijuana a few weeks ago. I don't know if it's in there or not, but just letting you know, just being honest with you. And he knows
So he got out of jail. He's not supposed to be using any drugs. Does he have a medical marijuana card?
no, but he will not use anymore. I didn't use it like the day before. It was before, Your Honor.
Pardon?
It was before. He used marijuana before he got arrested. I didn't use it after. And we can track the level. He's going to comply. I know he will.
I don't know that you can make that representation that you know that he will, because he's not thus far.
I have faith.
Okay.
Your Honor, may we?
Yes. May. All right, record should reflect we had a bench conference in this. And I'll just put it this way. While this might seem minor on this case, defendant is also on, and I'm not going to go into detail, but he's on probationary status at the time of this offense. Part of that probation includes that he should not be using drugs, should not be using anything, shouldn't have been using marijuana at that time. So what I will do is give counsel time to check into that and his potential violation of that probation. I'll adjourn this out 1 week to April 30th, 2026, 9 a.m. At this time, the defendant's bond is revoked. Defendant's remanded.
Judge Simpson's decision is driven by a larger compliance problem, not merely the possibility of marijuana appearing in one test. Defense counsel initially attributes the missed community corrections testing to transportation issues and confidently promises future compliance. That position weakens when the discussion reveals possible marijuana use and, more importantly, that Mr. Cadell was already on probation when the alleged use occurred. Probationary status can impose separate restrictions beyond the conditions attached to the current case, so the judge has to consider whether this conduct represents an additional violation. Notice how Judge Simpson challenges counsel's statement that he knows his client will comply. A lawyer can offer a plan, but personal faith is not proof, especially when the defendant has already failed to report for required testing. The defense does gain some credibility by correcting the record instead of allowing the judge to expect a completely clean result. However, that honesty arrives after an overly confident assurance, making the overall presentation appear less reliable. Do you think the transportation explanation adequately addresses the mistesting, or does the probation issue make revocation unavoidable? The 1-week adjournment gives counsel time to investigate, but the immediate remand shows that Judge Simpson is treating compliance as a present safety and supervision concern.
Hello.
Joy Gaines, Senior Assistant Public Defender, with and on behalf of Bird.
Hello. Morning. Your name? John Bird. Thank you. What are we doing?
Your Honor, I did reach out to Ms. Zinda because we did not receive discovery in this matter. I have spoken with Mr. Bird, who states this is a reauthorization case. So I did, both are. So I did go back to look through our file, and I cannot confirm for one of the cases that we did represent them. I believe it's my understanding from him that we did, but in terms of looking through the file and matching the dates that these have alleged to have occurred. So that's the first thing.
Just so I'm clear, what you're telling me is that you may not have discovery because you had a bit of a record on one of these.
Your Honor, I'll make this easier. It was resent yesterday for both files. I didn't realize it was the same in evidence items. We did a new meeting notice, so it should be released yesterday.
Got it. Okay.
Still not in my file as of last night when we met. I will check again. I have not checked this morning. So I am asking for some time for that, but I would also like to address bond. And if I could have one moment.
So if you're going to get the discovery, here's what I want to also make sure of. I don't mind adjourning it out, doing that, but I want to make sure if Mr. Bird's indicating that on the previous ones, that the public defender represented that there's not going to be an issue. What I would like not to run into, if we can avoid it, is all of a sudden you're here on both cases, but now you have a conflict and then it's put out and then it's further delayed. But we don't know that yet.
Yes. I do not believe that we have a conflict just based on my review of our representation of him in the past.
Got it.
And that it's the same complainant.
Okay.
We very recently represented him on a probation violation involving the same person as that.
Right. Okay. Then I'll adjourn this out to May 7th.
I was going to say, could we have a shorter period of time? And I will explain that in part.
Go ahead.
Even just a week would be fine. That is because Mr. Bird is the complainant in a matter involving this same complaining witness. This is a 2024 case. There is currently a matter where he is the victim. And this morning I was able to find that case and make copies of the register of actions for both Your Honor and the prosecutor. And he has been attending all of those court dates, but there is a concern that part of this case was dismissed in 2024. And I was able to confirm, as my client told me, that just before the meeting with the friend of the court in their divorce /custody proceeding, that the complainant came to the Washtenaw County Prosecutor's Office almost 2 years later, asking to have the matter reauthorized. As it states in the report, that does not mean it's not any less serious, but it is an interesting state of affairs. And he has a pretrial on the matter where he's the victim. He's been attending each of the case, all of the hearings.
That case.
That is in Wayne County, and that is on May 8th. And like I said, I was able to print that out for Your Honor and the prosecutor this morning when I found that.
And I want to say for the record, I spoke with the victim myself before reauthorizing this case, and she indicated to us that at the time these cases were dismissed, she was extremely terrified with the defendant and was not comfortable proceeding. She now has a better support system around her, and he had continued to harass her in the time since these cases were dismissed, and now she felt more comfortable and safe proceeding, and that is why these cases are now back before the court.
This is the central strategic dispute in the second hearing. The defense wants the age and procedural history of the allegations to create doubt about the need for the existing bond. Counsel emphasizes that the matter was dismissed in 2024, was reauthorized shortly before a custody-related meeting, and involves a complainant who is also accused in another case where Mr. Byrd is the alleged victim. That framing suggests a complicated personal conflict and raises the possibility of competing motives. The prosecutor answers the most damaging question directly. Why would a complainant wait nearly 2 years before proceeding? Her explanation is fear, followed by increased support and a greater sense of safety. Legally, delay does not automatically make an allegation false, particularly when intimidation or ongoing harassment is claimed. At the bond stage, Judge Simpson is assessing risk and whether conditions can protect the complainant, not deciding guilt beyond a reasonable doubt. The defense's family court recommendation describing Mr. Byrd as a good father does little to answer the alleged threats, which explains the judge's abrupt response that he is not sitting as a family court judge. Did you notice how quickly that evidence lost relevance? The defense may have stronger arguments concerning the competing criminal case, but it still must connect those facts directly to bond risk rather than simply attacking the complainant's overall credibility.
I also have, and I did not, because I'm not trying to retry the custody case, but I do have the recommendation where she speaks about what a great father he is and all of those things. So I wanted to
It's terrible maid.
You
right?
Can be.
That's it. So I don't know what that has to do with it.
But
I'm not a family court, so I don't know what that means.
But my point being is that I'm only trying to address these as far as bond and to have a court date next week so that he will be available to go to the pretrial hearing for the case where she hit him with her car.
Allegedly. Thank you.
Yes. Yeah.
So that's set for the A?
That is set for the A. So if we could have a 1-week adjournment.
All right. Any objection to it?
No, Your Honor, the discovery was sent yesterday, so we should have everything.
We'll adjourn it 1 week out to the 30th.
And Your Honor, we would ask that the court, considering how old this case is and that in terms of since that case was dismissed in 2024, there have not been any allegations or cases as far as Mr. Byrd. The only cases have been I believe there are 2, but definitely this one pending where Mr. Byrd is allegedly the victim. And so with that, I believe that he can abide by any orders, no contact orders or whatever the court would say would be appropriate so that he can continue to not only pursue this case, but also his rights as related to being a victim in the other case. And so we're asking for personal recognizance.
I'm going to object. This is 2 cases of aggravated stalking. In these cases, it includes threats to the victim that include the defendant texting her, "If I see you in Ipsy, I'm walking you, bitch. Don't be home. You need to learn to keep my name out of your mouth." That he will, everyone in the victim's car with her will get hit. And then this case came back to us because she informed us, and this was in a Washington measures report that is going to be edited with a related report, in which he was still continuing to harass her, showing up to her unit unannounced and calling her, looking at her social media posts. And that is why this case is dead. So I do have concerns for persons, given that even when the were dismissed, that pattern of harassment did continue. And I have concerns for her safety. Given
Your Honor, there's no allegations of any of those things since 2024. These are allegations from that case from 2024. We have not had any cases come forth. Pardon me?
That's not what I'm hearing.
December of 2025, that wasn't a different case that I somehow didn't get added onto this one as a later report. That includes allegations of him coming to our unit in 2025, December of 2025, and continuing to harass her. So I will add that and get that citizen today.
Your Honor, that was after those other matters were dismissed, and there continue to be parents together. But if the court implements an order, a no contact order, then he will abide by that order.
This, since I'm adjourning it out the 1 week, 30th, I'll just adjourn it out there. At this point, I'm going to deny the motion for bond reduction or modification of bond. Let you take a look at that other report, see whether or not that other report is relevant to the bond argument.
Thank you.
Thank you.
Judge Simpson ultimately denies bond modification because the defense's strongest factual assertion that there had been no further allegations since 2024 was directly challenged by the prosecutor. The state identifies a December 2025 report alleging continued unwanted contact, including appearing at the complainant's union, calling her, and monitoring her social media activity. Those allegations have not been proven at this hearing, but they are highly relevant to a bond decision because they potentially show continuing conduct rather than a dispute that ended when the earlier case was dismissed. The alleged threatening messages also matter. Statements warning the complainant about being home and suggesting that people in her vehicle could get hit give Judge Simpson a concrete reason to examine safety before relying on a proposed no-contact order. Defense counsel argues that Mr. Byrd will obey such an order, but that promise is weakened if the state can document contact continuing after the original dismissal. Would you accept a new no-contact order without first reviewing that later report? Importantly, the judge does not make a final determination about whether every allegation is true. He keeps the existing bond in place, schedules the matter for the following week, and allows the defense to examine the additional report before presenting another bond argument. That is a measured procedural response. Preserve current protections while ensuring counsel receives and reviews the evidence. The broader lesson is that bond arguments must address present risk with verifiable facts. Character evidence, custody disputes, and competing allegations may provide context, but they cannot replace a direct response to alleged threats and continued harassment. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.